let's take a look at the Wagner Act. The National Labor Relations Act was the first major modern U.S. law to deal with the legal issue of workers' employment rights in the general workforce in the United States. Employees shall have the right to self-organization, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing. The NLRA was considered to be very one-sided by employers when it was originally passed because it identified unfair labor practices for employers but identified no unfair labor practices for employee unions or labor organizations. The act was later amended to include unfair labor practices by employees and their representatives. The employer unfair labor practices identified by the NLRA include interfering with, restraining, or coercing employees in the exercise of the rights guaranteed in the NLRA. The NLRA is enforced by the National Labor Relations Board known as the NLRB, which was created by the Act. According to its website, the NLRB has 5 primary functions: conducting elections, investigating charges, facilitating settlements, deciding cases, and enforcing orders. It's also tasked with the investigation of any unfair labor practice charges and resolving those charges. In addition, when complaints of unfair labor practices cannot be settled, the case will typically be heard by the NLRB administrative law judge, whose ruling is subject to review by the NLRB itself. Board decisions may be appealed to a U.S. Court of Appeals and ultimately to the U.S. Supreme Court, if the parties are still unsatisfied. The last of the NLRB's task is enforcing orders. When a circuit court, an appeals court, or the U.S. Supreme Court issues a decision in a labor relations case, the NLRB is the enforcement arm of the U.S. government.